What's going on, people out there in YouTube land? It is the main man himself, the wolf, Mr. Bad, Mr. Werewolf, or also Mr. Sexy Coat. Got to keep up with my man, Fearless Floyd, out there. If you guys don't know about Fearless Floyd, go check him out on his channel. He's one of the best people out there, one of the most loyal, dedicated people I've ever met. So my brother from another mother, go check out the Fearless Floyd show on YouTube. He's on all the platforms underneath the same name. Go check him out. So Mr. Floyd, we got one up to you on the jackets here so far, sir. Let's see what you got. All right. Other than that, yeah, you guys can check out my cousin A6 Grind Time. He's doing his business over there also on YouTube. And shot goes out to all the other people out there who support and appreciate me. For those who don't, well, I appreciate you sharing my knowledge and my face anyway. But for those people out there who do follow me and do see people using my information as inappropriate, please make sure you hit that report button for bullying, slander, and defamation of character. All right. Appreciate that in advance. Now, if you guys weren't paying attention or you didn't see the other videos, this is a multi-part series on the book called A Treatise on Arrest and False Imprisonment, which you can get on blacksite32.com on the free document page at the very bottom. Should be uploaded by now. Otherwise, you can do a Google search and get it. It's out there in the public domain, so it is free to use, and they actually want us to distribute this type of information. I've used this book for many years. So this is this is one place where I learned some of the stuff. Also, if you can get your hands on any of the jurisprudence, juris secundum books, get them if you really want to get into what the real law is. Otherwise, contrary to many haters out there, I will use any source of information if it's valid, where it comes from, because there are some people and places out there that have real life knowledge on dealing with the system. And they're not always in books. And some of the brightest people I've ever met in my entire life don't have degrees. So you don't have to have a degree from the system in order to have this. I know one of my ex-girlfriends, when I was conveying some information, she's like, well, you're not licensed. Well, let me run this back to you real quick. A lot of intelligent people are not licensed, and a lot of people who are licensed are not necessarily intelligent people. And if you go back in the old days, the first people weren't licensed; they were private. Okay, and then people decide to commercialize it and then have their own standards. And there's nothing wrong with that. They just formed their own private members association, did their own thing. So to say that, oh, you're not official, or you're not licensed, what does that really mean? There's tons of people out there who have gotten what do you call them, honorary degrees because of their intelligence and their ability to do certain things. And so they were given an honorary degree. They're like, yeah, you have hands-on experience. So don't downgrade or disrespect somebody because they're operating in the private or because they're not licensed. Now, I'm not saying in some areas you should have a licensed person. I'm not, like doctor stuff and whatever else. You definitely want somebody, licensed. Somebody not licensed and doing things, they know what they're doing. That's cool. Just be careful because usually those are people who can't be held accountable. So that is one benefit to having a license or whatever else. But at the end of the day, have people either lost their license and, scam their way to getting back another one or whatever else. So yeah, so even the license side is not perfect. It has its own flaws and downsides. Anyway, I digress. Once again, thank you guys for joining me here on the YouTube channel known as The Bad Wolf or C Lovett. Nothing here to hide. I don't hide my name. I don't hide my face. I don't overtalk people. I just bring you guys, the information that I've been through and reading their books, bringing it to you. As always, vet your information, even if it comes from me or especially some of these other, people out here who are operating like clowns. Be careful because there are people out there trying to scam. Okay. Once again, I will stand on this forever. Most of these things you guys can get all are already out there for free or for cheap. So don't let people overprice you. Don't let people overtalk you or down talk you or disrespect you. Believe in yourself. And whether you're fighting the system or somebody who should be on your side but isn't, handle yourself as a non-belligerent non-combatant. Don't stoop down to their levels, or you will be no better than the very person that you say that you want to be better than. All right, so for the second time, I digress. Let's get into the video. So this is the last part of the series, and then I'm going to make, after this, I'm going to upload these, and then I'll make one video where it's going to be the full entire informational book straight through, as read by my lovely assistant. For those people who just want to go directly through the through without commentary. So all of these are going to be done with commentary, and the other one will not be. Okay. So let's get ready to rumble. And as always, guys, if you want any information, free files, as well as some paid, and as well as how to do the passport process and discounts and other services that you guys can use to help yourself out with food, rent, bills, and whatever else. There's lots of things you can utilize on Blacksite 32 that can lead you to those things and help you to improve your life and your livelihood. So let me see here. All right, let me share the page. All right. Share the sound, and we definitely want to make sure that it's in stereo. All right, guys, let's go. My lovely assistant, take it away.
8. Distortion of fundamental law. As we look at the common law principles, UD procedures for arrests which have existed, are hundreds of years as compared with the lay enforcement methods employed by most tyrannical forms of government, it is evident that we are closer to the latter. There are several reasons for this trend towards oppressive control over the citizen. Due process, neglected due process, or the law of the land, is to act a shield against arbitrary activity of government. Since the days of King John and Magna Carta, history shows it is the first link violated by overbearing rulers. In America, the due process provision embraces common law maxims and principles. In fact, there are many cases where the courts would cite the common law requirements for an arrest without warrant, but then would cite and follow some statute on arrest which was contrary to the common law principle. In nearly all of these cases where statutes contrary to the common law were upheld, we fail to find arguments asserting the requirement of due process of jure. And in very few of them was the arrest treated as a deprivation of liberty, which cannot be done except by due process of law. This departure from the common law rule on arrest is not all the fault of the courts, but also of those unlawfully arrested for failing to raise the proper arguments in court. While there are many cases in which the arrested party has asserted the common law rule on arrest, in most, they have failed to also claim the due process clause. Without such a constitutional plea, the statute prevails. Since the time this country was founded, there have been hundreds of cases involving false imprisonment or unlawful arrest. Yet the proper due process argument is scarcely to be found among them. It is amazing that in 200 years of our country's history, so few have argued this most basic and important provision of constitutional law in defense of liberty in such cases. This failure to claim due process in arrest cases over this period of time certainly does not say much about those in the legal profession. The incompetency of most lawyers was expressed by Chief Justice Warren Burger when he stated that 9 out of 10 lawyers are incompetent. Most lawyers are
9 out of 10 lawyers are incompetent. So that tells you that, yeah, not only do they get their little bar license or membership dues card, it's not a license, but they're incompetent. They get paid a lot of money to do really almost nothing. Now, there are some good ones out there, and my hat goes off to the good ones, but even the good ones out there are in a situation or a scenario where they cannot do anything because they take an oath. They take like two oaths, really, one to the Constitution and one to the bar as a bar member. Which one supersedes? Which one are they operating by normally? They take an oath in such a fact that it's to protect the bar first, then each other, and then their client. Ooh, how do I know that? Ew. The whole thing here is that they are prevented from giving you the short, easy, quick way out. Court is a court match. It's a volley of two different sides. Their superiors want them to draw things out, sit back, listen to the judge, and make a lot of money for doing very little work. A lot of the stuff that they do get done, they have their CPAs, right? Yeah, CPAs. Or what is that the right term for it? CPA. Yeah, let me double check. I don't want to misquote. I think I mixed that up here. Hold on. Pause. My bad. Not a CPA, a paralegal. Their paralegals are the ones who do a majority of the actual work. Okay. And then a good chunk of them will go on to then become lawyers or attorneys or whatever else from that point. So they cannot give you the short sweet. They know exactly how to get you out of most things. But at the end of the day, here's the problem, is that even if they do argue a good case, and I've seen this with a friend of a friend's lawyer, she won her case verbally, and the judge even admitted it after the fact, but he decided he still wanted to rule the way he wanted to rule. So then what good is really having a lawyer? I would contend that if you guys are going to be involved in any of this, that you go to take it to trial. And sometimes say, oh, this isn't anything criminal that you need to take it to trial for, blah, blah, blah. If you can get a trial, get a trial. Get a trial by your peers. And if it was me, I would indicate that I am a national or a state citizen. So I don't want 14th Amendment U.S. citizens. If I have to go on trial, then I want to be trialed by nationals. So good luck scooping up a number of them in the area. All right, so let's get back to it.
Lawyers are not independent thinkers. Instead, they are nothing more than programmed robots who follow the path laid down by the prevailing system, whether it be just or corrupt.
Did I not just say that? That is hilariously funny.
Corrupt. When it becomes corrupt, they will follow corrupt rules and statutes above fundamental law.
And by corrupt, let it be known that this is really stating that they know that they could do better service for you or help you out, but they're like, let's just milk it out a little bit longer. Let's just, like if they catch something that the judge did that's wrong, they're not going to say anything. If the judge wants to run over your constitutional rights or whatever else, it's very rare you're going to find a really good lawyer, because he has to balance making money for himself and his family and not pissing off the judge, who would know how to make and file a complaint against him and muck up his record. So it's a SHIT show. At the end of the day, it really is.
Law. This failure on the part of lawyers is especially remarkable when we consider the ancient existence of this due process guarantee, and that it is prominently found not only in our constitutions, but in Magna Carta, which proclaims, "No free man shall be taken or imprisoned or dispossessed, except by the legal judgment of his peers or by the law of the land."
And what my lovely assistant is having a trouble saying or pronouncing correctly is Magna Carta, not Magna Carta. It's Magna Carta, Carta. Something you should read sometime.
Land. 60. The word taken has sometimes translated as seized and arrested. The phrase law of the land means the same as due process of law, and refers to the law already established in the land. Thus no one could be arrested except by the established common law that prevailed in the land. It does not mean some new law that the legislature might devise.
Facts.
The due process argument in false imprisonment cases will nullify the statutes, rules, and ordinances that are contrary to the common law rule on arrest.
The law states, okay, so you read the Constitution and all that good jazz, that your rights cannot be abridged or abrogated. They cannot be ignored, stepped over. They can't form a bridge over those rights and in place statutes and codes, especially if they conflict. And where they do conflict, the law states you are to ignore those statutes and codes and regulations with impunity, because it is a sub government. All of these states and municipalities and whatever else, the federal government, which operates everything that is America and American, from the Constitution, Supreme Court, Bill of Rights, and the Constitution. Everything else is subservient, subpar. Don't get me wrong, they still have power and ability and finance. They are a force to be reckoned with. They are a functional entity, though foreign from the legal standpoint. And they are able to do that with the consent of the government. But when your rights and liberties and freedoms are being abrogated, abridged, ignored, trampled, disrespected, deprived, deprivation of your rights, the law says you are to ignore it. Now, I would ignore it in the proper way. Don't just be all belligerent and combatant, but stand on your rights. These are the things you have to know. Statutes and codes cannot replace natural law, God's law, the Constitution. Constitution is there. Some people say, well, I never signed it. I'm not really party to it. That's true to a certain degree. But if you are living by it, and you really have to understand that those documents are in place to protect your rights while limiting theirs, so they are directly party to it. We are more so indirect. It's there to protect us, but it is not limited. It doesn't limit us. Matter of fact, one of the most powerful ones, I believe, is don't quote me, but if you look on the Bill of Rights, I believe it's the number 10. Yeah, I think it's on the Bill of Rights, number 10, literally states that if there is something we missed, or as time and life moves forward, you as a state citizen, national, private person, American, have the right to challenge it and use number 10 to validate your opinion. You're not really sure your opinion, but your rights. So in other words, if something new comes up and they're like, well, and let's say, for instance, they didn't mention like your right to travel or something like that, you can use number 10. It's a very powerful open-ended tool to protect your rights and freedoms as we move forward. They say, look, guys, we're doing our best here, but we can't possibly see all the crooked stuff that these people are going to do to you. So use this. Here's your He-Man sword. I have the power. And you literally do. But if you don't look for it, then be happy with the gruel that they spoon feed you. If they're using a spoon, they might just, you know what, never mind. I'm not even going to say it. You get what I mean.
No legislative act can abrogate what is the law of the land.
I just said it without even reading it and knowing it. They just killed it. These lower courts are legislative. They are not in the position that they can abrogate the laws of the land. All right. Now, this is a gem drop, and I'm sure people will be using it in the future. But the law of the land when I did a search to find out what's the opposite of maritime and water admiralty jurisdiction, which is how they move, the proper term is terra firma jurisdiction. You should have terra firma jurisdiction on the bottom of your documents or on a seal. You should have your own seal made, your own micronation, or wherever you're operating from, your private trust or whatever else, and letting them know, because they're operating on water, we're on land. Right? Gem drop.
Land, otherwise there is no such thing as due process. Government BAS encroached upon the citizen's liberty by ignoring due process. The common law allowed arrests without warrant only for known felonies and breaches of peace. This is a required condition under due process of law in order to arrest someone. Thus it BAS been said that arrest without warrant, where a warrant is required, is not due process of law, and arbitrary or despotic power no man possesses under our system of government. Point 2. It should be quite obvious that if the legislature can say that arrests can be made without warrants for all misdemeanors committed in the presence of an officer, it can say that such arrests can be made when the misdemeanor is not in the presence of the officer. It also could say that such warrantless arrests can be made for mere suspicion, or because someone might break a law. All would be subject to summary arrests without question or warrant. One of the main reasons that a sword was put 10 King John to sign Magna Carta, and why the American colonists took up guns against King George III and his army, was to prevent the arbitrary acts of government in depriving people of their rights and liberties. Human nature as it is, such arbitrary action is the natural tendency of those having power in government, and whip out the due process provision. Government is free to encroach upon the rights and liberties of citizens with immunity. The term due process of law had a well-settled meaning when the Constitution was adopted. The framers thereof intended to perpetuate and secure the many principles, laws and rights, all of which could not be listed, against abrogation. Subsequent legislation cannot change the meaning or effect of this constitutional provision, and thus cannot change the procedure by which one is to be deprived of his liberty by way of arrest. An arrest cannot be done except by the law of the land, or due process of law. Fourth Amendment argument. Another reason for the distortion that BAS prevailed in the matter of arrests is the frequent misuse or misapplication of the Fourth Amendment in the U.S. Constitution, or similar provision in the state constitution, used as a defense to arrests without warrant. The Fourth Amendment, which guarantees the people to be secure in their persons, houses, papers and effects against unreasonable searches and seizures, generally does not apply to arrests made without warrants, but only those made with. For more information on this principle of law, refer to UFT, Ubidy and Property by the author. 2 Muslin v. Commonwealth, 86 Virginia 443, 10 C 534, 536, 1890. UNTS. The provision regulates how LLT 3.NLS are to be issued. No warrant shall issue, but upon probable cause, supported by oath. 2. If an arrest was made with a warrant, must follow the criteria of the 4th Amendment, otherwise it is an unlawful arrest, as the warrant would be illegal. But where here was no warrant, this provision is not applicable, rather we would apply the standards of due process of law. In one case in Illinois where a person was arrested without warrant pursuant to a statute, the person arrested questioned whether the statute is in violation of the search and seizure section of the state constitution, similar to the Fourth Amendment. The state Supreme Court said, but this section has application only to warrants. It does not abridge the right to arrest will hold warrant in cases where such arrests could be lawfully made al common law before the adoption of IHE present Constitution. 4. It is perhaps due to the ignorance of so many in the legal profession that we so often find this Fourth Amendment argument used as a defense against a warrantless arrest. The Fourth Amendment argument in cases involving arrests without warrant have been the most common defense raised, and the distortion in law it created has been all too great. Due to this erroneous argument, the courts have developed the concept that any and all arrests are lawful as long as there was probable cause. But under the common law, unless there is a felony. 61. Probable cause has no bearing on an arrest without warrant. Probable cause is to be a criteria in issuing warrants, but it now has been used as a means to get around using them in misdemeanor arrests. This is now adopted policy, and many modern court decisions reflect this distorted argument. J. Highway traffic laws. Traveling down the road today in an automobile through most any town, a citizen can become subject to hundreds of laws, rules, ordinances, and regulations which a citizen traveling in a wagon in 1900 never experienced. In fact, the bulk of these laws and regulations never could have been applied to the citizen traveling in 1900. Because of the exposure to traffic violations, the general public has been affected by many aspects of law enforcement that they would not otherwise experience. This experience includes arrests, seizures, stopping 10 check for licenses, registrations, or seatbelts, drunk driver tests, all kinds of automobile inspections, tickets, arraignments, and court trials. In examining the court cases over the years involving these traffic violations, there is a clear struggle and conflict between the fundamental rights of citizens and an extraordinary system of law enforcement. It is a system which is oppressive and despotic in nature, and which can somehow and arbitrarily deprive a citizen of his liberty. 3 I.M. Law Republic Annotation 586, 5 America Juris. 2d. Arrest, Section 2, page 697. 4 North v. People, 139 ill 81, 28 Ni 966, 972, 1891. See also Burroughs v. Eastman, 101 Michigan 419, 59 NW 817. 5. An example of this inaccurate argument of law was stated by the Supreme Court of Minnesota, which said, the test then, for the lawfulness of plaintiff's arrest is whether it was made with probable cause. Lundin v. Renteria, 224 NWZD 132. 62. How did such a system get a footing in America? This extraordinary control over the liberty of the citizen was established by having people sign up for a driver's license. As with any license, those who accept one agree to be bound by the terms and rules under the license. They consent to its rules. As an example, when a person consents to a search of his premises, that consent acts as a waiver of the right to assert that the search was unlawful, or that a search warrant was needed, and any evidence found in such a search can be used against that person. 6. In a similar manner, when citizens have accepted a driver's license to do what they already have a fundamental right to do, travel down the roads, they have in effect consented to a law enforcement system that is contrary to that known at common law or under our Bill of Rights. They have consented to the rules and regulations of this system and cannot argue the common law or the Bill of Rights, for they are not controlling when doing things under the license. One of the rules under the driver's license is that a licensee can be stopped at any time by a police officer and be required to display his license to him. As it is stated in a Minnesota statute, every licensee shall have his license in his immediate possession at all times when operating a mole or vehicle, and shall display the same, upon demand, by an officer authorized by law to enforce the laws relating to the operation of motor vehicles on public streets and highways. 1. Note who is required under this statute to submit to a stop and check by police officers and display their license. It is not every citizen traveling in his automobile, but every licensee, that is, those who have accepted a driver's license. The State v. Fish case also said that police officials may set up highway roadblocks for the purpose of requiring motorists to display their driver's license, and that such a practice does not constitute an unlawful arrest. It was firmly held at common law, as stated by Blackstone, that one would be guilty of false imprisonment by the act of forcibly detaining owed in the public streets. 8. It even been recognized in modern courts that officers stopping persons on the road is an arrest. When the officers interrupted the two men and restricted their liberty of movement, the arrest, for purposes of this case, was convoked. 9. However, such arrests or detentions are regarded as being reasonable, and don't need to fall within the common law exceptions. Why? Because the people stopped had driver's licenses. Since the vast majority of the people have voluntarily accepted the driver's license without objection, the courts have taken this as universal compliance with the licensing laws. Thus, where one does not have a license, it is regarded as public policy that they have no authority to drive the car upon the roads, despite the fact that they always had an inherent right to do so. Thus the courts. 6. City of St. Paul v. E. treated all citizens as being required to license holders, and subject to the corresponding rules and regulations under the NSE, including being subject to arbitrary WPS arrests and seizures without warrant. In a case in New Jersey, where two people traveling in an automobile through Jersey City, they were stopped and arrested by police, tficers, because they did not have a driver's ISOs. The two were taken to the station where they were held for investigation. The court held this oppressive procedure to be valid. It even cited the common law rule on arrest, asserting that olber than to apprehend a felon or prevent a breach of peace, the law did not allow an officer to exercise the function of determining whether there was a sufficient cause for an arrest. While this law on arrest had long been recognized in the state, the court accepted by stating, but the authority to arrest, in the circumstances here presented, is derived from Chapter 208 of the Laws of 1921, as amended by Chapter 171 of the Laws of 1931. This act requires the registration of all automobiles driven in this state, whether owned by residents or non-residents, and the licensing of operators of such vehicles. It directs that this license and the registration certificate shall be in the possession of the driver or operator at all times.
The one thing here is the keyword driver. Okay? Driver means for profit. So I like how they try to, the state here, they kind of try to bring in here all residents or non-residents, drivers. Okay? So they're splitting hairs. Okay? Because you have a resident, which is theirs, and then you're saying, but if you're here and you're not a resident, but you're still a driver, then, which means to be a driver means you've registered your vehicle with them. So these are the parts that you have to be able to understand. This is where they try to get you.
Limes. A further requirement is that the driver shall, when so requested by a police officer, exhibit his operator's license. Section 31(1) of Act 1921 vests in any constable or police officer authority to arrest, without warrant, any person violating any of the provisions of the Act, and bring the defendant before any magistrate. 11. Even though the common law on arrests was frequently upheld by the High Court of this, it PJNT v. Dokuski, 11-2 NJL 429, 170A, 825, 827, 1934. 12 Robertson v. S.O. 198S.W.2d 633, 635-36, Tennessee, 1947. 63. State in the past, when the driver's license law was enacted, the people were tricked into becoming subject to a new system of law enforcement. One that could arbitrarily stop and arrest citizens without warrant who had committed no felony or breach of peace. It is to be noted that there was no due process of law argument which would have nullified the driver's one licensing statute that allows arrest contrary to the common law. In like manner, there was no argument that the officers failed to take the two persons to a magistrate after the arrest, which even the statute required. Failing to raise the proper argument is always a fatal mistake.
So, like I said, do as I say, not as I do. Monkey see, monkey do, monkey pee all over you. The whole thing here is that, so even though they did it and they said, yeah, we did it, and you guys are good, they got away, just like they get away with every day out there, trampling on the Constitution and your rights, liberties, and whatever else. And it will be and can be filed away as good. It's valid. They have a right to do it. They did it. It's good. Judge signed off on it. It's fine, right? No. It means they got away with it because you didn't know which key segment to argue. See, you would think because, oh, well, they have to know where they deprived me of my rights and they're going to volunteer that they screwed up. No, half of them will lie and cover it. And I've seen them cover up things that they've done with other lies, other people involving the clerks. Oh, yes, I know you clerks out there watch. All right, I've been reached out to by numerous ones. Yeah, they'll make you guys party to these things too, and then you're in trouble. Oh, but then what do? You fire your boss and get into trouble there and possibly lose it, or get into trouble and possibly be facing treason and federal court cases. Yeah, that's a conundrum when you're working for the devil. Be evil. Damien Evil. And in some instances, traitorous to the United States of America and its people. So if you don't know how to dissect your case, and it's not even just dissecting the case, which is why we're going to have the seminars coming up soon. Like I said, we have the one or two started right now for VIP only. But so check the seminars page on Black Site 32 coming up. When we do open, I will make some videos. And in those, I will let you guys know that they're starting right now, like open for everybody. Like I said, right now, they're just for the VIP. We're fine-tuning some things. And so we've kind of come up with a very reasonable price for everything. As always, it's low compared to 95% of other people out there and what they're doing. I would like to say ours will be more comprehensive than most. There is no perfect or absolute, and these are going to be educational things. We don't take responsibility for how you guys do or don't do, actions or inactions, et cetera, et cetera. And it will be on a first come, first served basis. So once we get the VIPs through and everybody is up to par, we will open up those gates. And as you go ahead and just get the you buy your ticket, your spot for that particular seminar or seminars, whatever you want to do, no obligation, of course, then you'll be booked in. Once we hit that limit, we will probably do more seminars every month or every other month. I'm gonna try to do at least one a month, maybe two. It's a lot of work for me, and I have to get the team together. I'm trying to bring in other experts and stuff to for their things. So yeah, once we hit the cap at 100, literally, if you're 101, we will cut it because I can't overbook and then just say, oh, sorry. Um, Maybe we'll work out something where if people do buy past the 100 mark, that we'll send you a copy of the video or something like that so you can still get it. So I don't know yet. Like I said, we're still trying to fine tune this, and there's so many angles that you can play all of this, and we're trying to protect from people like just using information inappropriately and unauthorized, blah 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 blah. Unfortunately, there's so much stuff you have to deal with and prepare and protect and whatever. So, all right, but anyway, let's get back to it.
Mistake. In a case in Tennessee, which involved a misdemeanor, a man was arrested while he was traveling in the state. The Slate
Traveling.
Supreme Count laid down several good principles of law and related them to the American Revolution. It stated that the stopping of a car by an officer for the inspection of a driver's license, or for any purpose where it is accomplished by the authority of the officers, is in fact an arrest, even though it be a momentary one in some cases. This is a true point of law and anyone can see that such a stop is an arrest. But such an arrest is consented to by way of the driver's license, as the court further stated, one of the few
So in other words, if you have a driver's license, which I do not, I haven't had one in like 10 years, then that license means you are a member of their driving jurisdiction. Maritime, political, blah blah blah, all the way up to the half the sphere here, or the hemisphere. So having it, especially on your person, is horrible. But if they can find your name in the system and connect it with and form joinder with your address, which is registered and has the zip code, and they can put all that together, then they got you. That's why I tell people you're either all the way in or all the way out. But let's be real, because you guys seem to keep ignoring some of the things I say and doing it anyway. A lot of people out here will get have their driver's license and keep their vehicle in the system, which is fine. If you're going to drive, just drive. Some people then want to get the passport and use it while driving. Not fine. You're putting the officer in an awkward position because your vehicle's still registered, but you're telling him you're not this. Okay. And if I was an officer by law, I would still probably give you a ticket. Why? Because your vehicle is still registered with your name as a 14th Amendment U.S. citizen. You're in the computer. Now, many officers out there who know what you're doing and who also just don't want the hassle, who aren't as technical or legal savvy as me or the courts, they're going to go and say, well, the ones who do know, they go, okay, I know what you're doing. I just don't want to deal with it, or I back up and support what you're doing. So they let you go. But in all regards, legally, if your vehicle now, and let me say this, let me back up just a hair because there's a point of contention here. In my state, it's under statute 341.40, where you can have what's known as a foreign registered vehicle, which means your vehicle is registered somewhere foreign, like mine's to a private trust. And then I have plates that match that, or else it says non-resident registration. Okay, so as a non-resident, I have both of those taken care of, and affidavit of my declaration of being a non-resident to the state or any of those states on the corporate level. So your state may differ a little bit. That's why you have to pull your own codes and be willing to stand on it. But when you mix jurisdictions by trying to skirt by and trying to test some stuff and use the passport, well, once again, I call it out. Most of these officers watch these videos. Their superiors watch their videos. Hell, I'm sure they've had meetings where they're discussing my information and I'm on their screen. I bet you a whole bunch of more of them know who I am than I know who they are. And they're not all bad. Some of them are just trying to get right. So my hat goes off to you. The whole thing is that if you don't know you have the right to do it, but you want to make sure that you play nice in the sandbox. So when you're using your passport, what they do or can do is they'll take your name off the passport and go run it separately, find your name in the system, get your VIN, match it up, and then write a ticket based on that. Now, that is actually illegal. Now, they'll do it. This is one of the reasons why I say there's some points here. They'll do it, and if you don't know what they did, they'll get away with it because you don't know where to argue. You don't know where to point. But see, they cannot form joinder by using a different identification document from a different jurisdiction. They cannot use your federal identification, which is your passport, to then just run your name and form joinder. Can't use a different jurisdiction's document to do that. Now they'll do it, and if you don't know where to argue that, then they'll get away with it. But in regards, if you haven't removed your stuff from the system anyway, then you're still going to have to fight them in the district court. And you probably should win, but it's a whole lot of effort and money that you have to go through when all you needed to do is operate correctly. Because if the court sees that you still have your driver's license anyway, and your vehicle's still in your straw man's name, they're going to say, well, you're enjoying the benefit. You're not going to win your case up here. You're enjoying the benefit. This is what they're just saying here. They will only fully protect you if you are getting out of their system. You're out of their system, you remove their stuff, and then if they violate you by operating privately, then you can nail them to the wall. But if you're, once again, my dog poo cake theory. If you still have some dog poo and you put it in the cake, no matter how small, no one's going to eat the cake. Why? Because it's tainted. So if you're still using a straw man name and you choose to do right to travel, and this is for everybody, but it's not for everybody. Meaning you can do this, you do not have to do it. It's a right protected by the Constitution and the district courts. So this is lawful. Right to travel is lawful. That's why when you get the right to travel packet, it comes with all the cases, the opinions, excuse me, use the correct terminology, where it's already been decided. But the people on the state level, they don't read constitutional law. They don't care. And the problem is that, and I hate to use this word, but if you don't have it right, then in fact, from their perspective, you are looked at as a citizen of the, I can't do it. I'm not going to do it. Can't say it. You know what I'm saying? You know what I mean? Because what does that really mean? What they really mean is that you're a member of theirs who's not operating correctly. Now, how can they hold that to you? Because you are a member of theirs. I belong to a lot of fraternities, a lot of different organizations and whatever else. And if I go there and I start doing things that they don't like, they can threaten me with not being able to be a member of their community, or with fines, or, whatever else. Why? Because I agreed to these things. Go and get your driver's license. Go get the manual, the codes. They're going to tell you, we have the ability to do all these things if you are a licensee. If you're not a licensee, they can't do those things unless you're threatening public safety or endangering yourself or other people or doing criminal damage or criminal activity. All right, let's get back to it. Go ahead.
Exceptions of the law relating to arrests without a warrant is the authority of highway patrol officers to stop a car and demand to see the license of the operator. This authority in itself is not known to the common law and is of statutory origin only. In fact, the authority is implicatively given in provisions of the laws relating to the issuance of licenses, Zero Drive Automobiles, Point 12. 64. This statement makes clear the reason for the double quotes exceptions to the common law rule to arrest. It is the acceptance of a driver's license. The terms of the license allow on-the-spot arrests to check for valid licenses and whatever else the legislature or the courts may decide is necessary. IL. When one accepts such a license, then all of the sound and just principles of law, all of the constitutional safeguards, and all of the rights at common law no longer apply to them. Thus the decision here is not actually contrary to fundamental law, because the licensee waived his right to that law.
Waive the right.
The people, of course, were never told that such a license would remove certain protections of the law and suppress certain inalienable rights, nor will they ever be told this by the government. Resisting arrest. There are many cases on record involving actions against persons for assault of an officer or for resisting arrest. These cases are important in that they reveal the limitations of the executive officers in making arrests. And they reveal the high regard the law places upon individuality. It must be remembered that an unlawful arrest is in itself an assault and a trespass, and the law regards such arrests as any other assault which may be resisted by the party being assaulted. As a result, it is imperative that officers adhere to the law, as revealed by the Supreme Court of South Carolina. Common as the event may be, it is a serious thing to arrest a citizen. And it is a more serious thing to search his person, and he who accomplishes it must do so in conformity to the laws of the land. There are two reasons for this, one to avoid bloodshed, and the other to preserve the liberty of the citizen. Obedience to law is the bond of society, and the officers set to enforce the law are not exempt from its mandates. Where officers do not conform to the law of the land, they have no authority, and the right to resist them exists. A public officer, as with a citizen, who unlawfully threatens life or liberty, is susceptible to be injured or killed, for by such acts they draw their own blood upon themselves. As stated in some cases, where a peace officer has no right to make an arrest without warrant, B is a trespasser and acts at his own peril, 1:1. Due to TBs, resisting unlawful arrests is another area that has been distorted by modern courts. This is because police today are constantly making unlawful arrests, and if people ever become aware of their right to resist such arrests, a majority of police would end up dead or quitting their jobs. Without a police force, the corrupt government cannot enforce its corrupt system and could conceivably fall apart or die itself. Thus, distortions of law are declared from the modern courts on this matter, as was stated by a recent Minnesota decision. This court has, however, rejected THC argument that defendant has an additional constitutional right to resist an illegal arrest. 16. 13. It has been erroneously held that a STATE trooper can make a corrupt government would naturally not. W3.
Remember, everything here is considered educational, informational purposes only. We do not mean any harm or malice or anything towards anybody. Anything here is construed as just education. All right, so we don't want anybody hurt, so we are not condoning that. The AI is only mentioning that these are potential outcomes of such actions, as read in this document. So we are waived of any associations with anything negative happening. So make sure you guys govern yourselves always accordingly and carefully, and as a non-belligerent, non-combatant. And we're replacing the word DEAD with unalive. Okay. All right. So for the censors, and let's go.
OI people opposing it's unlawful and corrupt. Zazers. To show how judicially corrupt and invagid this decision is, let us look at some earlier decisions on this manner. Where an officer without a warrant attempted to make an arrest for a misdemeanor, and the person sought to be arrested had due notice that an attempt to arrest was being made by lawful authority, it was held that such person had the right to resist the attempted arrest. 17. The Supreme Court of Georgia later upheld this principle by saying, a citizen unlawfully arrested has a right to resist force with force in proportion to that being used to detain him. An unlawful arrest is an assault. The manner in which it is made may make it an assault and battery or a grave R offense. If no more than proper force is used by the person sought to be illegally arrested in resistance thereof, he is guilty of no offense. Generally, to slay a person who without authority of law is seeking to make an arrest for a misdemeanor, where the motive of the slayer is merely to avoid arrest, would be manslaughter, and not murder. Ls. In a case where there was transfer of an automobile, the new owner had called a police officer who, without warrant, arrested a woman involved because she refused to comply with his request to transfer the automobile, keys, and certificate. The woman resisted the arrest and was convicted of resisting arrest. On appeal, the Court of Appeals of Ohio said there was no offense committed by the woman in the presence of the officer, and there was no authority to make the 11 Franklin v. Emerson 65 arrest, and the woman was entitled to refuse to comply and to resist the officer. The court held, what of the resistance to the arrest? The A.L. Horleys are in agreement since the right of personal property is one of the fundamental rights guaranteed by the Constitution. Any unlawful interference with it may be resisted, and every person has a right to resist an unlawful arrest. And in preventing such illegal restraint of his liberty, he may use such force as may be necessary. Point 19. The law that allows one to resist an unlawful arrest is the same law that allows them to repel an attack or an assault upon them. It is the law of self-defense and self-preservation. 1 BAS an inalienable right to protect his life, liberty, or property from unlawful attack or harm. This law allows another person to come to the aid of one being unlawfully arrested, just as it does where one is being assaulted, molested, raped, or kidnapped. Thus, it is not an offense.
These are educational only words. Nothing here is real. This is only to display the fact that these are things that happen in the legal community and in the real world. Also, this is education, entertainment, informational purposes only. So please adjust these words to those that might not offend you. If you are offended, we apologize in advance. This is only educational information only.
Offense to liberate one from the unlawful custody of an officer, even though he may have submitted to such custody without resistance. Resistance. 2-0. In a case in Maine, a man had resisted an officer trying to arrest him, and both parties claimed that the other was the unprovoked aggressor and struck the first blow. The Supreme Judicial Court of Maine held an illegal arrest is an assault and battery. The person so attempted to be restrained of his liberty has the same regi, and only the same right, to use force in defending himself as he would have in repelling any other assault and battery. 1966 The court went on to say that the person illegally arrested cannot initiate the use of force, and fat words alone do not justify an assault. Thus, a mere statement by an officer that a person is under arrest, even if there is no authority to arrest, does not justify an attack by him on the officer before any physical attempt is made to take him into custody. This is basic law based on common sense, which would apply to any two persons who would have a dispute between them. But where the officer initiates the assault by physical contact, which is usually the case, and there is an unlawful arrest, the citizen has the right to protect his liberty to the extent of.
We're gonna skip this next word here for some obvious reasons. I don't want to trip any censors. If you guys want to read everything here on edited and whatever else, you can get the document yourself. Me personally, I just want to say that you have the right to protect yourself to a high extent, the extent of law and ability, depending on the severity of the situation. But be careful when doing so, and you have to ensure that you are in the complete right. Don't get any headstrong, righteous, thoughts of just, he said this, and then I'm just going to do this. All right. You have to be completely in the right to resist or to protect yourself. Okay. And so that's why you really have to learn this stuff. You cannot just go by bits and pieces. All right. So the short version of this is that, yes, if you're operating privately and the person is superseding your rights and benefits and privilege, or excuse me, your rights and freedoms and liberty versus your benefits and privileges, and you've exhausted saying, yeah, come get your commanding officer, don't touch me, I'm private, and your vehicles are good and all of that, because if you leave a breadcrumb for them, they're going to use that. But if you're operating truly private and truly in the proper way, then yes, the courts will protect you. But be sure that you're on the right. Don't you think you're going to squish some things through. Don't do anything for malice or evil or negative purposes. All right, so we're gonna kind of just muddle through this next section here.
Of killing the officer. As stated by the
All right.
Supreme Court of Appeals of West Virginia. What rights then has a citizen in resisting an unlawful arrest? 7. An arrest without warrant is a trespass. An unlawful assault upon the person, and how far one thus unlawfully assaulted may go in resistance is to be determined, as in other cases of assault. Life and liberty are regarded as standing substantially on one foundation, life being useless without liberty. And the authorities are uniform that where one is about to be unlawfully deprived of his liberty, he may resist the aggressions of the offender. Offender, whether of a private citizen or a public officer, to the extent of talking the life of the assailant.
Now,
If that
notice they
be
didn't say
necessary to
necessarily
preserve his
U.S.
own
citizen,
life,
right?
or prevent infliction upon him of
Because you're
some
either a
great
private
bodily harm. Point
citizen or you're a
22.
public officer. But
This
what
case was
happens is
cited and
when you
supported by
use
the Supreme
your
Court of Washington.
when you use a straw man, you become a public officer, a public trustee. You become one of them, a member of that whole side right there. That whole you are a sub entity, legal person of the public political jurisdiction.
Washington, who stated that the rule to follow is that the force used in resisting an unlawful arrest must be reasonable and proportional to the injury attempted.
Right.
The Crown held that 22 CLA versus.
So in other words, you cannot go all, crazy, crazy. You can do you. The problem is that if you do this, and I'm not recommending you do any of this aspect at all, unless like they're trying to RAPEU or something along those lines. It's easier to for the most part to comply, and then I mean, but if you feel like they're about to either unalive you or RAPEU, yeah, 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 go all in, do what you got to do, protect yourself. But if that's not the case, I highly suggest you be compliant, ask for a commanding officer. If you can before you're, whatever, dial 911 and ask for a sheriff or another department. Okay, to have more eyes on the scenario, record, turn on your phone, get a camera for your car, turn that one on. Um, more of them are getting body cams, and all of them should have it. But I find it interesting how they get away with turning their cams off and then getting not getting in trouble for having that go, turning it off, or the battery must have died at that point in time. All these little shady tricks that they do use and do. I've seen it. I asked one officer before he even started getting jazzy because he didn't know I knew my rights. I read his badge number and memorized it. And then I asked him, okay, well, what's your badge number? And he puts his hand over his badge and he's like, oh, you did this and this. And I seen the other guys look at it and I said, why are you lying? I was like, I can tell by, I was like, I already memorized it. And I said, and also your other guys back here looked at each other when you gave me that lie. So unfortunately, it's people like that, to my good officers out there, who give you guys a bad reputation. Because once again, I stand by it. How many bad officers do you have on the force? Usually there's upwards between 5 to 15%. And they're the ones who ruin it for the rest of you guys. If you guys aren't communicating what's going on privately and anonymously to internal affairs, I hate to say it like this, but do your job. Back to blue, and then you guys want to use the American looking flag for that. You made a choice to become a cop. Somebody like me, I was born this way. This is natural. You weren't naturally a cop, so do your job. If you're a good one, do it right. You're a bad one, or you don't like it anymore, you can't hack it, get off the force. Do something else. Just saying, just keeping it real. This is business. That ain't personal. Hurt your feelings, don't really care. Sorry, not sorry.
66. The court went on to say that the person illegally arrested cannot initiate the use of force, and fat words alone do not justify an assault. Thus, a mere
You cannot use more force than is necessary. It has to be reasonable, proportionate. And if it's not, then you will be held accountable for it. Okay, I don't want to read this next page. There's a lot of KILL words and things that have gotten on between some occurrences. So if you guys want that, go to get the book or document for yourself. Because like I said, I don't want to trip any of the censors here, and get flagged for certain words because we're not promoting anything negative here. These are real events, real court cases and things that have occurred. All right. So, but yeah, I think you guys get where I'm going with it.
handcuffing the people's lack of understanding of the law, or lack of concern for it, has allowed government to establish many unlawful and oppressive procedures in making arrests, etc. The use of handcuffs is a typical example of Ms. The practice of physical restraint by handcuffing. Leg irons, rope, straitjackets, and the like has historically been limited to those who had committed the most severe crimes, such as felonies, or have exhibited a violent temperament.
Well, that'd be nice if they didn't 100% handcuff people, or let me say it's 90% of the time handcuff people, even if they're just like, well, I'm just going to handcuff you for my safety. You're the one who's got full armor on. Got a backup, a network, a taser, handcuffs, billy club, vehicle, all that. But anyway, let's go.
Temperament. In Book 51 of the Lawyer's Reports annotated, page 216, are listed several cases which show that the rule pertaining to handcuffing procedures must depend upon the circumstances of each particular case. In citing an older English case, it was held that the right to handcuff one in custody may exist by reason of violence of language or conduct of that person. However, there cannot be any general rule that will justify a constable in resorting to the extreme measure of handcuffing a person in custody for a misdemeanor to a felon and marching them through the public streets, from the police station to the magistrate's office, for one who is accused of or guilty of.
So this tells you right here, they are not supposed to just handcuff you unless you are giving them beyond a reasonable doubt that you are dangerous and violent.
Guilty of a misdemeanor cannot be lawfully handcuffed while in the custody of an officer, and in some cases the prohibition extends to a felon. Usually handcuffing is justified only where one has attempted escape or has exercised violence toward the officer. But a constable cannot justify handcuffing a prisoner unless he has attempted to escape, or unless it be necessary in order to prevent his doing so. 3s. 69. There thus can be no general law which requires or allows the handcuffing of everyone arrested, as is the rule police now follow.
And they do it.
In the English case of Osborne versus Veatch, 1 Foster and Finn ENG Republic 317, where a lawful arrest was made for a misdemeanor, it was held that the handcuffing was utterly unlawful. When the person handcuffed sued the officer, a verdict was rendered for the plaintiff. Thus the unwarranted use of handcuffs is regarded as an assault and battery, and the person doing the handcuffing can be sued for the trespass. Post-arrest booking procedures, fingerprinting, etc. The entire concept of proper procedure of dealing with one in custody after arrest has been further corrupted by the liberal booking procedures and post-arrest tests. This includes such acts as fingerprinting, measuring, photographing, blood, urine and breath tests, dexterity tests, etc. This subject needs to be covered here as it is not only directly connected with the procedure of arrest, but involved the right of liberty as does the subject of arrest. In an early New York case, a man named Gao was charged and indicted by a grand jury with the crimes of grand larceny and forgery. Before his release on bail pending trial, a member of the police force of New York instructed Gao that he must come to police headquarters where he was to be measured, photographed, and fingerprinted. The Supreme Court of New York said 3451 LR.70 was the act of the officers of the police department in compelling the petitioner to submit to having his photograph taken and these measurements and imprints fingerprints made a lawful or an unlawful act? To subject a citizen, never before accused, to such indignities, is certainly unnecessary in order to detect and arrest him, for he must have been detected and arrested before he can be so dealt with. 2. Is unnecessary to prevent crime, for the acts for which indictment has been found, if criminal, have already been committed. The exercise of any such C. Police power as is here contended for is contrary to the spirit of Anglo-Saxon liberty. The acts of the police department bear criticized were not only a gross outrage, not only perfectly lawless, but they were criminal in character.
So the cops themselves are doing criminal things. You haven't even been convicted. How are they taking your prints, your picture, which are your materials, before you've been convicted? You have not been convicted of a crime. So why? So if that's the case, well, let's just say that we're going to talk a little bit more about this in some of the seminars, but yeah, it's not constitutional. You've not been convicted. And there are ways for you to get your materials out of there, and there are ways to prevent them, if they do these things, to get paid even more and protect them off the rip. I've used them.
Character. Every person concerned therein is not only liable to a civil action for damages, but to criminal prosecution for 3 Salt.J6. The court also made it known that it was the duty of every member of the police force, under penalty of a fine or dismissal from the force immediately upon arrest, to convey the offender not to police headquarters to be photographed and measured, but before the nearest sitting magistrate that he may be dealt with according to law, page 1016. This was not only required by the city charter, but by fundamental law. The Galt case was upheld several years later by the Supreme Court, in a case where it was acknowledged that the taking of the plaintiff's picture before conviction was an illegal act. 31 in 1926. A law was passed whereby all person charged with a felony, specified misdemeanors, and one species of disorderly conduct, shall forthwith, upon arrest, be submitted to fingerprinting, a practice before permitted only after conviction. The law prohibited anyone being admitted to bail until they were fingerprinted to ascertain whether he has previously been convicted of a crime. A New York court stated that the new law involved a serious invasion upon the liberty of our people, and gave several reasons why such a law was not constitutional. Article 1. Section 5 of the Constitution of the State of New York provides, excessive bail shall not be required. The prohibition against excessive bail necessarily includes the denial of all bail. A defendant is arraigned, in fact innocent, and refuses to submit to fingerprinting. A recoilment from it is not unnatural. It cannot be said that the refusal is unreasonable or unjustified. Yet he is denied bail. The requirement for fingerprinting is oppressive and unreasonable. it contravenes Article I, Section 5, of the Constitution of the State of New York, and in my judgment is unconstitutional. There are other grounds upon which the unconstitutionality of the law must be declared. Article 1, Section 6, of the Constitution of the State of New York provides, "No person shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty or property without due process of law." Fingerprinting is an encroachment on the liberty of a person. It is justifiable, as is imprisonment, upon conviction for crime, in the exercise of the police powers of the state, for the purpose of facilitating future crime detection and punishment. What can be
Right. But they do it now, have you in there, and make money off of you because they're for profit. So everybody who's out there has been fingerprinted before they got charged with something and convicted. They denied you of your right. It's an encroachment on your liberty. They did something illegal, unlawful, and then use these things to convict you with other stuff and link you to this and that. These are violations. You can sue for that. Now, I'm not a lawyer or a liar or an attorney or any of them jazzes, so you'll need to go and do your own thing. But you have been so informed. You have been duly noticed.
can be its justification when imposed before conviction?
So in other words, what I'm saying is don't contact me to pick up a lawsuit for you. I don't do that. I would just give you the keys. And once again, these are not done. If you want me to review something, basic information on how you can set yourself up to fight. And I don't do it for people who hurt kids or drug-related stuff, et cetera, et cetera. Okay. Not anywhere where you've hurt somebody or anything like that. But if you do want to chat, it will be under a special fee, which is not the normal consult fee. Okay. So in all honesty, you can go to Black Site 32, go to the bottom of the page, and there is a consult option there. And I believe it's a $5 or $5.50 for that particular chat. Okay. About an hour to an hour and a half. If we go over and I decide to, then it's fine. Just need the basics. And I can try to point you in the correct direction on where to fight and how to fight, and then where to take it, and then where to move from there if you are not successful. Okay. Once again, everything here is educational, entertainment purposes only.
Conviction? Talk barge that one's fingerprint records have been taken would ordinarily convey an imputation of crime, and very probably support a complaint for libel per esse. In my judgment, compulsory fingerprinting before conviction is an unlawful encroachment upon a person, in violation of the state. 36 GOAIV. Constitution. Constitution. Lastly, fingerprinting before conviction involves prohibited compulsory self-incrimination. Point 18. The very idea of booking and making a record of one's fingerprints, photographs, etc. are acts commonly done to convicted criminals, and thus implies one is a criminal. Corrupt governments are inclined to treat all citizens as criminals who break the smallest law it has passed, and process them as such without due process of law. All must be regarded as guilty until proven otherwise. Some cases in Louisiana were decided, which asserted that the power to fingerprint, etc., is constitutionally restricted to the identification of the hardened criminal. Such measures upon an accused were held to be unnecessary, q. prove his guilt or for the identification of his person or to guard against his escape. 39. A federal district court held that there is no right given to government by the common law to take fingerprints. 0. The principles of Anglo-Saxon government certainly would not have sanctioned such intrusive and oppressive measures. In New Jersey, the Superior Court stated that the police cannot lawfully fingerprint an accused person against his will. 41. But later, in the case of Bartletta v. McFeely, 107 N.J.EQ,
But see, here's
One
the thing. So also, when this has happened to me, I in fact informed them of this and said that I am formally refusing this, but I will comply because I am not going to, I don't want to be construed as a belligerent and combatant, though I have the right to be in this moment. And I was unlawfully arrested and subjected to this. So I told them, yeah, just know that this is a formal notice that I am refusing this, and this is against my constitutional rights, but that I will not physically resist. But I'm not going to offer any type of assistance. I'm not helping whatsoever. Okay, that's how you do that.
141, 152 Atlanta 17, and New Jersey court went contrary to this position. The merits of that case have often been questioned and criticized. As one text writer asserts, 71. The Chancery Court of New Jersey, it is submitted, reached a most unjust conclusion and utterly devoid of all reason, wherein it was held an arrested person charged with crime could be lawfully fingerprinted, measured, and photographed without his consent and against his will. Such unreasonable decisions, as this, go a long way to strike down personal liberty and invade rights that have been thought, ever since this government was established, to be inviolate. 42. The Banlela case had indeed gone a long way to strike down personal liberty, as modern cases that allow such measures find their authority traced back to this unjust and frivolous case. When one bad case is decided, another follows it, then another, and all because the act or measure supported is more convenient for government, not because it is pursuant to fundamental law. In 1945, the Court of Chancery of New Jersey made an exhaustive study into the law and cases surrounding the act of fingerprinting, etc., and reached the conclusion that there is no justification for the taking of fingerprints, photographs, and other measurements in advance of conviction. 43. Closely related to these measures is the act of compelling one to submit to blood tests, urine tests, etc., after arrest and before trial, to be used as evidence at trial against the person arrested or accused of a crime. In considering the act of compulsory blood tests, a New Jersey court based its decision on the constitutional right to personal privacy and 38 People v. Tvun, 127 Miscellaneous, re page 141, 215 New York Sup. 412, 417, 41 8, 1926. 39 Shulman v. Whitaker, 42 So. 227, 11-7 La 704, 1906, Ilskavert v. W. H. Attaker, 42 So. 228, 117 Law. 708, 1906. 40 on Ild Slats I. Kelly, 51 Fed. 72. Acts, as the court said. To subject a person against his will to a blood lest is an assault and battle cry, and clearly an invasion of his personal privac. Y.44. This is another area which has been corrupted in order to satisfy the convenience of government at the sacrifice of the inherent or constitutional rights of the individual. The modern trend of the corrupt courts are to limit the protection of self-incrimination to evidence obtained by oral utterances, and not any physical evidence. There are, however, other good cases which have held that a compulsory physical examination of a person accused of a crime is inadmissible, as it is a denial of the right against self-incrimination. 45. We thus can conclude that there are at least 5 reasons why the acts of compulsory fingerprinting, blood tests, etc., are unlawful. 1. They are an evasion of the right of privacy. 2. Compels evidence to be used as self-incriminating evidence. 3. Is an assault and battery. 4. Violates due process of taking one arrested first to a magistrate. 5. Prohibits bail. and infringes on one's liberty. Limitations upon arrests. The common law drew certain limitations upon how and when an arrest can be made, and thus all arrests are to be grounded on such standards. But the ignorant and corrupt in government have always been bent towards broadening the causes and reasons for making arrests. One limitation often transcended is the sufficient cause required for a felony arrest or breach of peace. No one, whether private person or officer, has any right to make an arrest without warrant in the absence of a tool b ef, based on actual facts creating probable cause of guilt. Suspicion without cause can never be an excuse for such action. The two must both exist and be reasonably well-founded. 46. The word suspicion is found more frequently in statutes and codes to authorize arrests that the common law prohibited. In a case where a man was arrested for belief he possessed stolen goods, a felony charge, the arrest was held to have been unlawful. However, the police sought to justify the arrest upon the fact that, although there may have been no reasonable cause to believe that the man was guilty of a felony, yet he was in fact guilty of the misdemeanor of carrying a concealed weapon. They claimed that, although the weapon was concealed, the offense was committed in their presence, and it was suspected that he did have a concealed pistol, which was found after the arrest. The Supreme Court of New York held that their arguments were groundless. An officer cannot arrest a man for one cause, and when that cause is exploded, defeated, justify fo r and not he r. Such a doctrine would be an incentive to the loosest practices on the part of police office, and a dangerous extension of the IRSU.
So in other words, they're essentially saying, which has been done to me before and many others, that they kind of escalated the person, all right, or sometimes you escalating the stop. Having suspicion that he might have something on there, on him, on his person, and I don't know, I don't have all the information. They believed he was in possession of stolen goods, but they couldn't prove it. And then upon in searching for him, they then found a concealed weapon. You can't do that. If you do not have enough suspicion that it's obvious that you like a huge, like some meat hanging out or whatever he stole, proof, camera, something, like you got to be sure. And you check this person. Okay, you don't have the right to do that. And then you find the weapon, and then you're like, well, we're going to book him on the weapon then. Can't do that. Once again, the RAS, reasonable articulable suspicion. Now, if they've got witnesses that said they seen him do it, and he's got a ham under his jacket, and they got the video, yes, they can, yep, and I won't go into all the side things, but then, yeah. Okay, and then they could have got him for the whatever he stole, say if it was ham, and then the pistol. Okay, but you go for one thing and you can't prove it, and then you continue. Oh, we're just going to keep searching you and hope for something. Can't do it. Well, they do it, but it makes it unlawful. So let's see how this turns out if they talk about it.
Sufficiently great powers. They cannot be too firmly told that there is no such lawful thing as an arrest without an apparent or disclosed cause, to be justified thereafter by whatever may turn up. You cannot arrest a man me rely, because, if all were known, he would be arrestable. You must arrest him for some. 44 Bednarik vs. Bednarik, 16a.2. 45 State vs. 46 People. Specified cause, and you must justify for that cause. 41. The court cited an early case in which there was an arrest under a warrant, but it was unlawfully executed in the nighttime. It was held that there was a false imprisonment the moment the officers took the plaintiff into custody under to-be warrant. When the officers demanded admittance to the plaintiff's spouse, B fired off a revolver. They defended their action upon the ground that, as the revolver was then used in their presence, under circumstances which constituted a crime, they // justified in arresting the plaintiff. But the court justice Haight writing held that they were bound by the arrest under the warrant, and could not offer another cause sufficient to warrant the plaintiff's apprehension in justification of their action. 48. This leads us to another point on arrests, and that is whatever reason or justification an arrest is based upon. It must not occur at a time when an arrest is not allowed. The common law set limitations on when an arrest could be made. Arrests were allowed at nighttime, and warrants were of no effect at that time. An arrest for felony, treason, or breach of peace could, however, be made at any time of the day. The general rule of law is that an arrest made on Sunday or other holiday, or at night, except in cases of pressing necessity, is regarded as oppressive and without justification.
Now that's interesting. I don't know if that still stands, but that's interesting because if they're saying that an arrest can't be made at night, that's when the majority of the arrests are made. There must be something more to that. I've never heard that one before. But they can't arrest you at night. That doesn't, to me, that doesn't even make sense. I would almost argue for the law on being able to arrest people at night. So I don't know. This might be that section might be old or archaic, or I might be missing something to that. But the common law sets the limitations on when an arrest could be made. Hmm. All right, hold on. Let me check something out. Just want to look around real quick. So common law has been codified. So in other words, they took that which was in just in you these things make sense, common law. They codified it, turned it into code. So parts of it are still effective, parts of it aren't. I mean, you could always still argue the old common law that, but they may not try to hear it depending on where you're at. Um, okay, so misdemeanor arrest may be served anytime, anywhere, day or night, except when the suspect is not in public, but not already in custody. For example, in his residence. So for a misdemeanor arrest, if he's in the public, that's one thing, but it says the warrant may not be served between 10 p.m. and 6 a.m. unless the warrant is endorsed for night service. Huh. Interesting. Interesting. Did not know that. Okay, so they cannot serve a warrant between 10 p.m. and 6 a.m. unless it has night service on there. So once again, another little feather for the cap. So if you have been violated in that way, you have a lawsuit. If you're in the public at any point in time, though, they can book them down. Okay? So there you go. Good to know these things. Let's get back to it. About to wrap this up soon.
Justification. The reason underlying this principle of law is due to the difficulty in making bail at such times. So an arrest made on Sunday, locale holiday, or at night, upon either civil process or a criminal warrant for a misdemeanor which said warrant does not involve a breach of peace, still in progressal, subjects the officer to liability as for false imprisonment. 49. 73. In American Law Repons, annotated, Volume 9, page 1352, it states that arrests should not be made at night or on Sunday, citing Bryan v. Comstock, 220 SW 475, et al. As this is a common law concept, it is also due process, and cannot be abrogated by statute. It has been said that the constitutional protection regarding arrests and searches is to be applied to all alike, the completely innocent and the completely guilty. If an arrest and search can be made without warrant because of known guilt alone of any misdemeanor, then the one barrier designed to protect persons from unlawful invasions of their persons and property would be destroyed. 50. An arrest can be justified by the concept that the end justifies the means. No one who properly appreciates the sacredness of personal liberty, and the jealousy of the law in guarding the same, can doubt that, as a general rule, the law requires a warrant in order to render an arrest legal, whether it be made by a policeman or any public officer. 51. In order that government might deviate from the common law, it was necessary to eliminate common law officer, sheriffs, constables and watchmen, and replace them with the policemen.
Did you hear that? So they do no longer have common law officers. The sheriffs, constables, and the watchmen, they replace them with the policeman, policy man. They're corporate. They're operating under the state's constitution by a for-profit corporation, which is technically foreign to the United States of America. Because the other ones had to operate directly under the Constitution. So though they may use the word sheriff or whatever else, a lot of them, though they're supposed to still take their oath, are working for profit. Now, not all of them. I don't know how it ebbs and flows, ins and outs, but I have some say that they're constitutional and some have said they're not. The Constitution, not the states. So it is what it is. But none of them are untouchable when it comes to lawsuits, depending on what their actions are. All right, so let's keep it moving.
A police officer, unknown to the common law, is a creature of statute, and as such can only exercise such powers as are given by the legislature, expressly or derivatively. 52. 47. 74. 74. Conclusions. The wisdom of the ages which brought about the law on arrests was boldly declared in Magna Carta. No one shall be arrested or imprisoned but by the law of the land. This is called the common law, and it is made constitutional law by the Due Process Clause. While this fundamental law appeals to individual liberty, it does not appeal to despots who express their will via corrupt statutes and judicial opinions. It comes down to the question of whether fundamental law is going to be controlling in this matter, or if legislative statutes and the will of despots are to be the prevailing law. Between these conflicting alternatives there is no middle ground, one or the other must be paramount. In considering the matter of arrests in Anderson's treatise on the law o/sheriffs, is this noteworthy comment: heed should ever be paid to the voice of common law as Il has echoed down through the ages, loudly proclaiming in the interests of the riles of the citizen, that it must not be forgotten that there can be no arrests without due process of law. And q est without was has never been lawful except in those cases where the public security required it, and this has been confined to felonies and to cases of breach of the peace committed in the presence of RHE officer. People today are obviously not being arrested or imprisoned by the law of the land. Those in the governmental system fail to see the logic in the common law principles, and find them to be an annoying restriction in their task of getting the crooks or bad guys. What they fail to understand is that this is exactly the point of the common law, to be restrictive upon those in government, to make them follow set procedures, and to make it difficult to deprive people of their rights. The common law prescribes that in order to safeguard the rights of the innocent, the guilty must on occasion go free. This sentiment was expressed by Sir William Blackstone when he said, "1 is better that len guilty persons escape behind a hat one innocent suffer." 2. In this country constitutions were written to restrict the actions of those in government.
That's what I
But it
said.
is daily being violated by judges, legislators, and police on the topic of arrests, which makes them lawbreakers. As
Facts.
Justice Campbell said in the famed Saraway case, official illegality is quite as reprehensible as private violations of law. The law of the land must be accepted by everyone as the only rule which can be allowed to govern the liberties of citizens, whatever may be their ill desert. 3. These officials should be asked, why is it we have less liberty today than did subjects living under a monarchy? It is because the subjects of the king had the benefit of the common law, the ancient principles and maxims that have been acknowledged for the security of life, liberty, and property.
That's it, guys. That is it. Hopefully, you guys learned a lot in there. I know I learned a lot from this book myself over the years, and it has assisted me in adding more feathers to my hat. Well, I'm not wearing one right now. Just call me Mr. Coincidquaddle or Cuckoo Khan. All right, more feathers in my hat. So there, beyond that section, there's an addendum where there's a couple of cases that they're talking about and whatever else and how to attack it. These are a lot of things that I already know how to do. Um, and so those are some of the things that you can learn on your own. Like I said, we're going to be doing the seminars, which will be essentially a group consultation. Everybody will be learning everything from we're gonna have different ones. You know, we're gonna have one that's gonna be a couple hours on the court by itself, and then we'll have ones for like health and esoteric stuff and maybe trusts and whatever else. So um, you know, people who are experts in their fields, I'm gonna try to pull some people together and see what we can get going. Um, this has already been very successful with other people I've worked with and been a part of theirs, and so I'm gonna, you know, utilize some of their resourceful information, maybe some resources to bring what they're already doing with their successful campaign over to our channel and provide you guys with a lot of deep quality information from a lot of specialists and people who are really good at what they are doing, some licensed, some not, et cetera, et cetera. So, with that being said, that's it. Don't forget to hit that bell, like, subscribe. And once again, you guys can get this document off of blacksite32.com. I'm still going to contemplate, I guess, if I'm going to just have the straight, you know, shot. Because if I do, I'll have to make sure that I you know, like I did before in this one, edit out some of the words because we don't want some of those words, you know, keying off the YouTube AI censors. So that's about it. Check out blackslide32.com. And with that being said, you guys have a great day. Good night. Take care of yourselves and each other. I'll talk to you later because we got a whole lot more files and things to do, books to read. And for me, now that I've dropped these videos off, I'm gonna take another quick breaky break, and get some more things done on the personal side and then on the public side. So that is it. All right, guys, I'll talk to you later. Enjoy yourselves. Have a great day. Peace.